Ladies and gentlemen, may I apologize and draw you away from your conversations. If I can speak for myself, I'm having a thoroughly good time, and I'm glad so many people seem to be doing so as well. But it's now that stage of the night where it's my absolute pleasure to call to the podium in a few moments the Honourable Brian Selley, QC, also Adjunct Professor of the University of Western Sydney, and extraordinarily good friend to academic staff and colleagues as well as students. And I wanted to thank Mr. Selley for all of his service and commitment and attention he has bestowed upon us for over the years. And now it's my distinct pleasure to ask Mr. Selley forward to introduce our speaker for this evening. Mr. Selley.
Pro-Vice-Chancellor, Deans 1 and 2, Director, and that's as many names as I am going to build into the protocol of the evening, except, of course, for Mr. Gleeson, who is, as always, in a class of his own. It is, of course, a great honour to be the patron of the Law Alumni Association, but I can't honestly say that it's a very burdensome one. Once a year or so, I am summoned from my little office on the outer fringes of the university and am asked to take a cameo role, a blast from the past if ever there was one, and to introduce the guest speaker on a particular occasion. I am, of course, always pleased to do it, but never more so than tonight, because to have the responsibility of introducing to you, of all people, the Honourable Murray Gleeson, is something that gives me, if I may say so, a very real frisson of personal pleasure and satisfaction. Mr. Gleeson and I go back a long way. We were contemporaries at the University of Sydney. I was not in his class, not actually, not academically, not indeed figuratively in any other sense that has ever been apparent to me. To introduce somebody like Mr. Gleeson ought, in those circumstances, to be completely simple, but I have not found it simple at all. The reason for that is that Mr. Gleeson's achievements have been so singular that they are not so well known as legendary. And to be asked to introduce a legend, believe me, is not a small thing to be asked. What are the options for doing it? There are two. One can take what I would call the who's who option, that is to say, to invite everybody to sit quietly, bored stiff, while one takes them date by date, time by time, place by place, office by office, through a wilderness of material, which anybody sufficiently interested can see for himself or herself simply by pulling down the latest edition of the Who's Who in Australia, or I suppose in this day of IT, is that what I should be calling it, IT, by going online, by doing a Google. I heard somebody say, I'm not quite sure that I understand what's meant by doing a Google, but I'm assured that you can, and that it yields information of various kinds. There is another option, and if you'll bear with me for a few minutes, it's the one that I would prefer to take. It's the option of trying to put, shall I say, some anecdotal flesh upon what otherwise would be bare biographical bones. You know, of course, that Mr. Gleeson was for a decade or so the Chief Justice of the Supreme Court of New South Wales. You know, I imagine, that the law provides that the judges for the time being of the Supreme Court are ex officio the judges for the time being of the Court of Criminal Appeal. So Mr. Gleeson, as Chief Justice of the Supreme Court, was at the same time the presiding judge in the Court of Criminal Appeal. And I want to speak just for a moment or two, if you will allow, about some aspects of that part of his work. The Chief Justice was always concerned that the Court of Criminal Appeal should dispose of its business as rapidly as justice would permit. To that end, and leading as he always did by example, the Chief Justice frequently gave judgment ex tempore in the Court of Criminal Appeal, hoping thereby to encourage those of his judges who had a taste for the adventurous to do the same. I understand that in an age when there are sullen resentments of all kinds seething not too far below every social surface, there might well be people to say some such thing as, well, what about that? He gave judgment ex tempore, big deal. But it is in fact a very big deal. For a judge to give judgment ex tempore in any case, and certainly in a criminal case, is not by any means the same thing as thinking out loud while you are cobbling together the weekend shopping list. In order to give judgment ex tempore, and to do it worthily, there have to be two things firmly in place. One is quite simply a natural gift. There's no point in wringing one's egalitarian hands about it. It's a gift from God, and you either have it or you don't. The other thing has to be the honing of that gift. There's not much point in having it if you don't use it. So it is important that the judge, who is going to embark upon this perilous course of an ex tempore judgment, should have over time and by patient and steady and disciplined application honed his natural gift so that it comes to fruition as a great art. And I don't mean a great artifact or artifice, I mean art. Mr. Gleeson had the natural gift and had it in abundance. By the time he came to preside in the Court of Criminal Appeal, he had more than amply honed it into a very fine art indeed. And so when he came to give a particular judgment ex tempore, he would begin to speak. And he would speak slowly and deliberately for nothing more than perhaps 3 or 4 minutes. And a perfectly formed paragraph would come out. And then he would stop, actually stop, for no great time, half a dozen seconds. Believe me, if you were seated beside him, as I often had the privilege of being, it felt like 10 minutes, because so immediately and so completely had the Chief Justice riveted the attention of everybody in the court that if that often invoked pin had happened in fact to drop, everybody in court must have heard the sound. And then he would speak again, exactly in the same way, and another perfectly formed paragraph would come out. And that procedure, speak, pause, reflect, speak, would go on until the Chief Justice had said the whole of whatever it was that he wanted to say in the particular matter. At that point, there was in hand on the record a judgment delivered ex tempore, to be sure, but a judgment so complete, so precise, so finely crafted, that it would have been quite simply a waste of time to have reserved it for later delivery, because there would have been nothing of value that could possibly have been added to it as it then stood. I suppose all of that doesn't sound a great deal when one says it quickly. But take it from me, they were masterly performances. And what made them masterly was that they were stamped always with two characteristics. I thought at the time, and I think still, that those characteristics go a long way towards explaining the spectacular achievements of Mr. Gleeson, both at the bar and on the bench. The first characteristic was succinctness. You know what it means, and I don't need to say anything more about that, except perhaps because it would be seemly, and it certainly would be timely to say that in connection with succinctness, I fear that I am still not in Mr. Gleeson's class. As to clarity, it ran through everything that he said. clarity of focus, clarity of analysis, clarity of argument, rationally structured, logically deployed, and clarity, I always thought, a singular, remarkable clarity of English expression. That is to say, English the language, not English the contemporary dialect. Many of you will have read the biography by Professor Ayres of Sir Owen Dixon, another titan of the bench and bar. In his case, the Victorian bar, but you can't have everything. At the frontispiece of the book, Professor Ayres quotes a couple of lines from one of the satires of Horace. It's a piece in which Horace, a very great poet, poses for himself this question: who then is the free man? And he goes on to establish this way and that some things that he believes make up the free man. And he finishes by saying, and these are the words that Professor Ayres puts at the front of his book: such a man is a man in se ipso totus, teres atque rotundus. He is a man complete in himself, polished and well-rounded. It is obvious, is it not, that a person who satisfies that description is going to be in constant demand to speak on occasions of the present kind. It is just as obvious, is it not, that such a person, however talented, cannot fairly be expected to accommodate any and every invitation that he receives. So much the greater the compliment that Mr. Gleeson pays us by his ready agreement to come and join us this evening, which, for the reasons to which Mr. Jurians has already referred, is such a very special evening in the life of the law alumni. May I say just one more time what I said last year, and will go on saying as long as I am here. You, ladies and gentlemen, who are alumni of this law school, are fundamentally important to it. Your continued enthusiasm for the school and interest in it are a dynamic and essential part of its continued existence at all, never mind its continued existence in a worthwhile form, carrying out the very important mission for which it was founded in the first place. All of that said, therefore, pray silence for the Honourable Mary Gleeson, a companion in the Order of Australia, one of Her Majesty's Council, lately Chief Justice of the High Court of Australia, sometime Chief Justice of the Supreme Court of New South Wales, Mr. Gleeson.
Dean, Your Honours, ladies and gentlemen, it's a great pleasure to be with you again, as has been mentioned, in this lovely historic place. The clearest recollection I have of the opening of the law school at Westmead is that the Westmead campus includes what used to be called Westmead Boys' Home. And I remember on the walls out there pictures of the orphan boys. I remember the pictures of them at work making boots. In the 1950s, when I was at school in Sydney, the Westmead Boys' Home was well known as an orphanage for boys. This is the first time I've ever been to the female orphans' home. Brian Sully, in his extremely generous introduction, referred to my time on the Court of Criminal Appeal, which was a very interesting place to be. I can remember, for example, sitting on the Court of Criminal Appeal when the late Justice Roderick Marr sat on his first criminal appeal, and I thought I'd better sit with him. And we sat together on the bench, and he looked down at the court, fixed his gaze firmly on a person in the court, leant over to me and he said, "You've only got to look at him to see that he's guilty." I said, "That's the sheriff's officer that you're looking at. They haven't brought the appellant up from the cells yet." Actually, the late Justice Marr was a good illustration of one of the principles or one of the perils involved in giving extempore judgments. He was sitting on an occasion in the Court of Appeal of New South Wales. The President of the Court of Appeal, Justice Kirby, was presiding, and there was a third judge sitting with them, and at the end of the hearing they decided they could give an extempore judgment, and the third judge was asked to deliver the first judgment, and he delivered it over a period of about 20 minutes to half an hour. And then the presiding judge, Justice Kirby, said, "I've listened with great admiration to the reasons for judgment of my brother so-and-so. I agree with his reasons and his conclusions, and there's nothing I can usefully add." And Justice Marr said, "I agree." An English statesman of the Victorian era famously said to Queen Victoria, "Change, Mum, why do people want change? Aren't things bad enough as they are already?" Well, why do people want change? Some people want change for reasons of self-interest. Young people, for example, have a vested interest in innovation. If you have a comparative disadvantage because of a lack of experience, self-evidently, innovation is in your interest. It minimises your comparative disadvantage. It can even render irrelevant the skills of some of your more experienced competitors. But many people also want change for altruistic reasons. They think it's for the good of other people, for the good of the community generally. And most people can distinguish between change and progress. Nobody aged 75 believes that all change is for the better. I imagine nobody over 25 really believes that. So there's a need for discrimination between change that's progress and change that isn't. In many areas of commentary, perhaps even in some university circles, words such as progressive and conservative are used with the same intellectual content as hooray or boo. My purpose tonight is to make some random reflections on some kinds of change that affect the law, the substantive law, legal process, or the legal profession. In the area of substantive law, an obvious starting place is the Constitution. And in constitutional law, an obvious starting place is relations between the federal, the Commonwealth and state governments and the allocation of power between them. Now, you're all familiar with explanations of why, over the years, the High Court has demonstrated zeal for centralism at the expense, so it is said, of state rights. Sir Edmund Barton, during the convention debate, said when people talk about states' rights, they're usually talking about states' interests. But the explanations for the expansion of Commonwealth power at the expense of state powers and the alteration that that has made to what is sometimes irritatingly called the federal balance are thought to be fairly well known. The shifting of taxation powers from the states to Canberra, the expansion of the external affairs power, the expansion of the corporations power, a variety of other ways in which power has shifted from the states to the Commonwealth. But there's another explanation that seems to me equally important that's very rarely mentioned. In 1900, the sources of governmental power affecting Australia were not merely Commonwealth and state. There was an elephant in the room. Australia was part of the British Empire. There was imperial power. Australia went into 2 world wars during the 20th century, not in consequence of any decision made in Australia, but in consequence of decisions made in London. At the beginning of the 20th century, enormous power affecting the Australian policy was exercised in Westminster. After World War I, then the Statute of Westminster, then World War II, the imperial control withdrew. The tide of empire receded. But power abhors a vacuum. So where did that imperial power go? Most of it went to the Commonwealth government. What did it encompass? For example, it encompassed matters of defence, external affairs, back in 1900. It seems to me that there's very little occasion for surprise that now the allocation of powers between Commonwealth and state governments is substantially different from what was envisaged in the year 1900, because in 1900 they had imperial power to contend with also. And that imperial power has mostly devolved upon the Commonwealth government. The corporation's power is another good example. I retired in 2008 in the middle of the global financial crisis. And for a year or two after that, there were demands always upon the Commonwealth government to take steps to deal with the effects of that crisis in Australia. Can you imagine what the public would have said about the proposition that it should be left to the states to deal with the effects of the global financial crisis in Australia? That proposition would have endangered federalism itself. If there hadn't been an expansion of the corporation's power to enable the Commonwealth government effectively to deal with a matter such as the global financial crisis, the consequence would have been a fundamental questioning of the concept of federalism. Let me move to another area of substantive law. One of the biggest changes during my time in the law has been the emphasis upon human rights. I would draw a contrast between rights and interests. When Dr. Johnson said that patriotism is the last resort of the scoundrel, he wasn't being unpatriotic, he was simply drawing attention to the fact that many scoundrels wrap the flag around themselves. And many people who are promoting their own interests wrap themselves in the banner of rights, demanding interests under the cover of rights, because in the present climate, to identify something as a right is to play a forensic trump card. Now, one of the problems that the law has to deal with, that politics has to deal with, is that rights conflict with one another. Privacy and free speech, for example. But one of the great political, in the broadest sense of the term, issues that we have to contend with, and you find it being dealt with in Australia in the difference between the way the Victorian and ACT governments have dealt with this and the way the other governments have dealt with this, is the extent to which the courts will be given the capacity to implement rights. Let me give you an illustration of what seems to me to be a problem that has to be confronted in relation to this. There's a very interesting case called Odievre against France, which is a decision of the European Court of Human Rights a few years ago. You can Google it, and it's worth doing. It's worth Googling this case and reading it. The European Court was divided something like 13 to 11 in the outcome of this case. But I raise the case simply to raise for your consideration the issue of policy that I mentioned. The issue in the case was the lawfulness or the compatibility with the European Charter of Human Rights of some very old French legislation concerning the protection of the anonymity of women who put their children up for adoption. And an applicant in the case, a young woman who was an adopted child, asserting what she said was her right to personal development, challenged this law on the basis that she couldn't find out the identity of her natural mother. This is a subject of considerable historical importance in France, because in the days of St. Vincent de Paul, churches used to have in their exterior walls towers that could be moved around, and somebody could place an object in the outside and it could be turned to come to the inside, and people would put babies in these and they would then be turned around. The purpose of this system, obviously, was to encourage women who didn't want to keep their children to use this system to avoid abortion and infanticide. That was the object of this system, and the system was taken up in legislation which guaranteed the anonymity of the mother. And so there was this conflict that was resolved by this narrow majority decision of the European Court of Human Rights. By a majority, the court decided that the French law was valid. But my question is this: is that the right way to solve that problem? That is, submitting it to the decision of a group of judges. There are some issues in a liberal democracy that might be resolved in a way that you don't agree with, but if they're resolved through the parliamentary process or through the democratic process, you'll accept the resolution. But I'm not sure that, for my part, I want judges deciding an issue of the kind that was decided in that case of Odievre against France. And of course, we're familiar with the problem of the overstatement of rights. I can remember a good practical example of that when I was a junior barrister. A New South Wales government decided to abolish, in almost all cases, civil jury trials. In the 1950s and 1960s, most civil cases in the Supreme Court of New South Wales and the District Court were heard before juries of 4. They were mostly personal injuries cases, but that was the typical way of dealing with this form of litigation. And the New South Wales government announced a policy of having trials by judge alone in civil actions of that kind. And of course, the barristers, whose skills lay in jury advocacy, found, and this is a typical example of change, their talents about to become irrelevant. And they published a document called Your Right to a Jury Trial, seeking to persuade members of the public that it was the inalienable right of a person who had a claim for damages for being run over by a motor car to have that determined by a jury and not by a judge alone. It's probably not necessary to make any other comment about that particular campaign than to say the civil jury actions in New South Wales and throughout Australia today are almost entirely unknown. But we were being told 30 or 40 years ago about our right to a jury trial. The third area of change in relation to substantive law is the search for overarching principles. I suppose the most famous case of the 20th century was Donoghue and Stevenson. I can tell you, actually, this is a true story. When I was at the bar, a solicitor who used to ring me up for impromptu advice over the telephone once rang me up and he said, I have a client who drank a bottle of soft drink that had something in it that caused her damage. Has she got a cause of action? I said, yes, actually, there's a case in point on that. And he said, that's fantastic. But you take the concept of proximity in relation to tort actions. That's an example of a search for some kind of overarching principle, following from what Lord Atkins said in Donoghue and Stevenson. But note that the consequence has been increasing complexity, increasing elaboration, accompanying the search for unifying or overarching principle. I can't answer the question why that's happening. Why does the law continually become more complicated? Everybody knows that you don't make a game fairer by increasing the number of rules, but that's what we're about in the law. Let me turn to the matter of legal process. The length and complexity of cases is an obvious change that seems irreversible. It brings with it increasing inaccessibility of justice. Costs and delay have been complained about in relation to legal process ever since there was legal process. But you've probably heard many other old lawyers say this, but when I was a young man, a long case in the district court was one that was going to last more than a day. Criminal trials were commonly over in a day. Once again, I'm not sure I know the entire explanation for this, but I do have a conviction that justice ought to be a little rougher than it is at the present time, because what we get at the present time simply means that justice is unattainable for many people. Another example of change in the area of legal process is the impact of technology. I saw an interesting example of that last week. I was in Melbourne and I, for a reason I won't go into, was in a jury room in the county court in Victoria for a while. And on the wall they had a notice to jurors giving them instructions about what to do and what not to do. Head of the list was, do not engage in your own research. And that was elaborated by saying, don't go into Google, don't go into Wikipedia, don't try and look up the criminal record of the accused person, don't try and research the law. Decide the case on the basis of the argument and the evidence and instructions you hear in court. But that's only a modern example of an old problem. There's always been a problem about jurors doing their own research. About 30 years ago, there was a case in the Court of Appeal in England where at a murder trial, the jurors had consulted an Ouija board and they had asked the deceased who was responsible for her death. I forget the name of the accused, but to pick a name at random, the deceased said, according to the operator of the Ouija board, Brian Sully done it. And the person was convicted. There was the question that then arose before the Court of Appeal was it open to the Court of Appeal in hearing a criminal appeal to invade the privacy of the processes of the jury? Could they receive evidence that the jurors had done this? Now, It's a miracle of legal enlightenment that the outcome of that case turned upon the fact that the jurors consulted the Ouija board in a hotel where they were sequestered overnight and not in the jury room. So the court said, well, there's nothing wrong with asking them what happened in the hotel. We're not invading the privacy of the jury room. And they allowed the appeal and ordered a new trial. Warnings against research by jurors are not a new problem, but of course it's been magnified by the availability of technology. And the third area of change, worth some comment, is that affecting the legal profession itself. About 30 years ago, some people involved in public policy conceived the idea that it would be better for the public if members of the legal profession behaved like business people. Evidently, these persons had never met a business person. But they then imposed upon the legal profession, in the interests of making it more businesslike, a number of changes. It would be a great loss to the public if the concept of professionalism, even the concept of elitism, were lost. One of the great problems facing the professions at the moment, and facing the legal profession in particular, is to try and find ways of persuading young people coming into the profession that it's a good thing to adopt the requirements of self-restraint, limiting the pursuit of self-interest, that are essential to the concept of professionalism. It's also important to remind young people, and people in an audience such as this need no reminding because you all pursue this yourselves, that people in the professions owe an obligation to their profession. Francis Bacon said, "I hold every man a debtor to his profession." And one of the important functions of a law school, I should have thought, is to remind people who aspire to enter into the legal profession that when they do, they will become debtors to that profession. There are various ways of discharging that obligation. Bacon said one of the ways of discharging your debt to your profession is through the humane and liberal practice of the profession. Another way is to participate in the conduct and regulation of the profession itself. Another way is for people to regard it as a worthwhile aspiration to undertake judicial office. Let me conclude by saying that obviously change is part of our natural condition. We all keep changing, mainly because we have to do that in order to remain the same. There's nothing about change that requires us to be despondent, but there's a great deal about it that requires us to be discriminating.
My thanks for your address. May I please call upon Mr. Jonathan Adamopoulos, the University of Western Sydney Law Association's alumni president, to offer the vote of thanks. Jonathan.
Thank you, John. Chief Justice, the Honourable Murray Gleeson, Justice McColl, the Honourable Brian Sully, the Honourable Bob Davis, Professor Adams, distinguished guests, colleagues, ladies and gentlemen. It is a privilege to have been asked to propose a vote of thanks on this occasion. Tonight marks a very significant milestone for both the alumni and for the university, two very large anniversaries. and it's very fitting to have a topic addressing the very issue of change. 200 years ago, thinking about it, there was no official Supreme Court. And in the 200 years, we've now not only seen a Supreme Court, but tens of thousands of legal professionals across the country in a federal court system. And the issue of change is one that many professionals struggle with, not only in the substantive aspects that we've heard about the changes in the law, not only in the procedure and the great pressures placed, if you like, in the business aspect, or as in the demands that are placed on the profession and the achievement of justice, but also in how the profession operates and the changes that we see as professionals. So on behalf of the University of Western Sydney, the Whitlam Institute and the Law Alumni Association, I would like to offer my sincere thanks to the Honourable Murray Gleeson, ACQC, for his time this evening. We are very appreciative in light of the very busy schedule that Your Honour still has. Thank you. I'd now like to call upon Mr. John Jurians to offer a small gift of our appreciation.
Jonathan, if you remain upstanding. Mr. Gleeson, if I may call you forward to offer a few small tokens of our thanks for your address. I think you can guess what the first one is, and I hope you do enjoy that.
Tony.
And in particular, I think you might find this new publication of great interest, particularly at page 133, where your image appears of a shot taken 17 years ago. Thank you very much, Your Honor.
Thank you.
Thank you very much, Jonathan. And it's now my distinct pleasure to call upon the Dean of the School of Law at the University of Western Sydney, Professor Michael Adams, to offer the last address of the evening and to bring these proceedings to an official close. But I do hope you are all able to remain for a good while longer and enjoy each other's company. Dean.
What an honour, ladies and gentlemen, to have the last word. And I was thinking, after such wonderful speeches, how would I wrap these proceedings up without, first of all, going through a whole list of important people. And I was thinking, right at the back of the room, there are some of our students. These are not alumni yet, they're our current students. So whatever we have some of our honour students, would they like to stand up? And I can name you if you want me to, so I think it'd be better. So Mel, would you stand up? And Taylor, you're a current student, thank you. These students represent the future. And so when we talk about change, those of us in the room who have the privilege to be lawyers, to be part of an honourable profession, owe a great deal to know that these young men and women will take the UWS way of doing the School of Law into the profession to have a profound impact. At our table, we were talking about Twitter and Facebook. We were talking about Mr. Sully's iPad. We were talking about, actually, I'm not going to tell you anything else we were talking about, but you're a generation that will use that information, you'll use your legal training, you'll use your resources to change the world in the way you feel appropriate. And I have to say, the small part each of us plays, whether it be as a teacher or as a judge or as a practicing member of the profession at the bar or as a solicitor, you are why we do what we do. And we know that you, particularly tonight, represent the very best of what this school produces. I think it'd be great to show, a round of applause to our future generation of lawyers and to enjoy the reflection for the future. To our future lawyers. I do feel like a teacher or a principal. You may sit down. Thank you for doing so. And I have to say, some of their honours theses are amazing. And I actually particularly want to show a tribute to Carolyn Sappadine, who also, of course, is one of our deans, as with Razine and Rob Warner. Carolyn still coordinates our honours program, and we're very grateful for that hard work. My last thing to do, and I think we're actually going to probably receive some dessert, is simply to say, on behalf of the Vice-Chancellor, thank you very much for coming and being part of this celebration. It is a milestone, but one I look forward to the next 10 years of alumni, and hopefully, obviously, the Silver Jubilee of the University, of the Law School, and for the future. Enjoy the rest of the evening. Thank you.